So today was the hearing about the motion to stop that survey that the defense had put out in the Brian Koberger case, the Idaho 4 case. And it kind of started out Bill Thompson just talking about the non-dissemination order, and he read off the non-dissemination order and then read some of the questions from the survey, trying to explain how he felt they violated the non-dissemination order. And then both he and Ann Taylor reiterated that she did not write the questions, that she hired a third party to conduct the survey. And so those questions were written by them. The first hint of concern by the judge came when it was admitted that they didn't believe the person that wrote the survey was given the non-dissemination order.
Mr. Edelman, was he aware of the dissemination order?
I don't know if he was aware of that or not, but we gave him no information in the case, Your Honor. He received nothing from us.
Things start to heat up from here because Judge chastises Ann Taylor over the survey, saying they had worked so hard to get a fair trial and that that's what the non-dissemination order was about. And he felt like that survey was doing the same thing that they didn't want done with putting information out there to the media. And after he talked to her about that, then he went straight into her accusation that the state was trying to violate Brian Koberger's due process rights. So it gets really juicy here.
Sorry, it's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial. Okay, and our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Koberger, to get a fair trial. And some of these questions actually create a concern about, that they're inculpatory. It could be prejudice for his client. Okay, and that I'm just surprised that both of you didn't come together and say, there are certain things that we probably shouldn't put into the public on a telephone call. It really concerns me, and that's why I did what I did that Friday. Now I'm being accused of violating a due process, which is a whole big issue for me.
I can understand that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard. And that's going to delve into our argument on due process.
So Ann Taylor then goes into explaining why she believes what happened was a violation of Brian Koberger's due process, to which Judge was not having that. He basically had her back up. He went through the timeline. He explained how the motion process was the correct legal process and how he had concerns over the survey, and that's why he decided to sign the motion to halt it. And then he asked her point blank what her understanding of due process was. So she goes on to explain it in the next clip, and things are still a little bit heated between the two of them.
Sure.
And that was my motion. And I asked you to set aside the order that you made without having a chance to hear from us, making a decision that now you're locked into. And it was a one-sided decision.
I'm not locked into anything. My order didn't say it was permanent. And it told you that I was going to have a hearing.
Maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday. Now it doesn't even reflect, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I filed an
That's what I
objection the
got.
minute I could.
Because then you know that about 5 o'clock, that's when I issued that. So I had a half an hour. I read the materials that were attached to the motion that the state filed, and I had very little information. But it seemed like there were some real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about what was done in the survey. So in the my order, I told you that I was going to set a hearing. So I don't know what your understanding is with just the process. Okay, but I on Friday sent this hearing. So what are we doing today? Okay, I'm hearing you out. You had notice. I mean, really, that's what we're talking about. That's what the law. What is your understanding of due process?
So Anne goes on to explain her understanding of due process and then continues to be upset about the surveys being halted. And she claims it's setting her back 2 weeks. To which Judge looks really irritated and explains that it really isn't setting her back because there's not even a trial date set. So it isn't like there's any hard and fast dates going on. And they can always move out that change of venue hearing.
My understanding is that I should have notice and an opportunity to be heard.
And you did that.
I'm having that now, but there has been a decision made by this court almost 2 weeks ago that stopped us from completing our work. I understand that Mr. Thompson raised a concern, and his last paragraph to the court in his motion was, it seems that it may have violated the non-dissemination order. And so we're stopped from completing our comparative surveys right there when we're up against the deadline to get to our motion to change of venue. I'm looking at, it stops me from doing the work and meeting the deadlines to argue for Brian to be in a place where he can have a fair trial. I think the court should not have issued an order stopping us, but set a hearing, shorten time, set it for Monday morning. If the court wanted to set a hearing for that Monday morning, we wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been more damage. I mean, this less than 2 weeks really has very, very little impact, okay, on your work.
It does have an impact, Your Honor.
You don't even have a trial set. Come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial, so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem, what sets me back, is getting my work complete to get my briefing to the state in the time and the deadline that I was already given, and meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here, okay, if there was some communication between you and the state about the survey.
Now, if you notice, he said it all could have been avoided had the prosecution and the defense communicated with each other. And then in this next segment, you'll see Ann Taylor still trying to defend the process she took while still criticizing the process that the prosecution and the judge took. And the judge was still not having it. And he still had concerns about it violating the non-dissemination order, was still concerned that the person conducting the survey didn't know about the non-dissemination order. And he also mentioned that it was all done behind his back.
Apparently, Mr. Alden did not even see the non-dissemination order, and you apparently did not give that to him. So this is a very not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people, without a permission of the court, without discussion with the state. I mean, that's troubles me. And then when I'm being accused, directly accused, okay, by you in your brief, that I violated his due process rights. Now, that's not what the law says, and that's not what the facts are. And you even cited cases that say exactly what due process is in the law, right?
I understand that, and I agree that's what due process is. My issue is that the order was signed, stopping our work without a chance to be heard. It's as if the state and the court had decided we violated the non-dissemination order, and we didn't.
All I was doing was stalling it, okay, for less than 2 weeks so we could have this hearing, number one. Now, if you feel like you've been prejudiced or your client has been prejudiced for less than 2 weeks, okay, in this work, I'll push it out. I'll just push out the trial. I mean, not the trial, but the hearing. I mean, is that satisfactory?
Your Honor, I think that might be what we need.
Fine.
I need to figure out if we're going to be able to continue the surveys. But if we are, I expect that we will need some additional time to get them done so that I can get the work to the state to review.
Okay, well, that's a different issue. I've never said, no, you can't do a survey. This was a total shock to me that Friday at 4:30.
I can understand that. It was a shock to the
I had to
state.
stall it out, okay? Because so that we could all talk about it and figure out what is the right path. Okay, because this is a big deal. And I take it very, very seriously. And I was surprised, okay, that this was happening behind our backs, my backs. Okay?
So Anne went on some more about how these surveys are normal, not an anomaly, but the judge again reprimanded her and said the problem was with how it was done.
How it was done. I'm not concerned. I figured there was going to be a survey at some point. There would have to be. It was the way it was done, okay, and the questions that were asked. That is the real problem, as Mr. Thompson pointed out.
And then Anne and the judge go back and forth again about whether this is planting seeds out there, whether it's a violation of the non-dissemination order.
Lifted 100% from the media, 100% already in the public record. And it is a one-by-one conversation. This isn't something that's being put out there through social.
Well, it kind of is.
Well, now it is, but I certainly didn't expect
400
this.
people, okay, it's planting some seeds where then people are encouraged, or they think, oh, wow, I didn't know that. I'm going to look more into this. I mean, again, we were trying to keep the false information that was out there in media land, that it wasn't going to affect your client.
Anne then went on to discuss about how she didn't believe that the survey violated the non-dissemination order. And then she got onto the subject of the person that conducted the survey finding that Latah County was biased. So Judge wanted to know how that person came to that conclusion. And he also made a comment that everyone has a little bias.
The results aren't compiled yet. I anticipate he'll recommend we change venue. Where we are now is we'd like to finish the other 2 counties. You don't have to do 2.
You did say that he said that Lake County is biased.
I anticipate he's going to recommend we change venue for that reason.
I'm interested from him how he defines bias.
And
We all have some biases.
I will not put words in his mouth for that one.
I'm not expecting you to do that.
So then Judge brought up about Ann Taylor questioning him about signing something that the prosecution had asked him to do. And she was not too happy about that. So he brought up that she had never given a response to it. So what she got really feisty about it. And yeah, they were going back and forth again.
Other situation that you brought up, Ms. Taylor, about that there was a prior thing where I had done that about the IPV.
Yeah.
And the state asked to do a public order just to say that we provided the IDG or some of the IDG to you. And that doesn't really say anything except that. But you were criticizing me for that too.
Your Honor, to be clear, it's not the content of that order. My concern is the process. My concern is it feels like from our perspective that Mr. Thompson says, hey, Judge, can you do this? And I'm getting ready to weigh in and it gets done.
I didn't get a response from you.
Your Honor, that was out the same day. I was in the process of writing, and this was by letter. It wasn't by motion. I was in the process of writing a letter to the court asking to be heard on some issues, and the order was signed.
So then Anne went on to say that they need to better define what an emergency is because she's still upset about the judge signing motions with hearings coming afterwards. And the judge pointed out her hypocrisy in stating that she has filed motions without also asking for hearings. And then the judge basically came to the conclusion that they should try to have monthly meetings, him with the prosecution and the defense, to try to clear up a lot of these things so that they're not going back and forth with all of these motions as often or not communicating like they should.
I think maybe we need to define emergency a little bit better because I know you have those powers and I wouldn't ask you to not use the powers that you have. I think the problem here is the way this gets presented when there were a lot of different roads and it cuts us off. And that's what I don't want to have happen.
Okay, I want to solve this problem if it's possible. One of the things, I mean, because you have filed motions where you didn't ask for a hearing. There's still one, couple hanging out there. Okay. And so I don't know if I'm waiting, okay, if you're asking for a hearing or not, or because historically you guys have worked really well together. Okay. Stipulations, but then I don't get a stipulation. I don't get a request for a hearing. So what am I supposed to do then? So what I'm starting to wonder about is maybe we should just have a hearing, okay, at least once a week. I mean, a month, maybe once a week.
I'm here every week.
Maybe
We can
once
do
a
it.
week. Okay,
We can do it.
like a Thursday afternoon. Okay,
That's the day I'm here.
and then, oh, okay, so, and then we can kind of clean out a lot of these things that are sealed or, arguments about this or that. I don't.
After that, Bill Thompson spoke again and he reiterated that it was a violation of the non-dissemination order. But then he brought up that he was disappointed that the defense did not give the person they hired to do the survey a copy of the non-dissemination order, that he had not been made aware of that.
I have to say, I am disappointed to learn today that Dr. Edelman and his associates were not made privy to the non-dissemination order.
Now, Anne brought up about how Latah County is a close community and how people had called the prosecution's office and law enforcement when they started receiving the phone surveys. And that drew a rebuke from Judge because he felt like she was stereotyping them. So take a listen.
And that this is a close community, and I understand that people will call officers with concerns and the prosecutor with concerns, and that's kind of the thing that I'm worried about, is the close-knit nature of it. That's a good thing unless you are an outsider having a trial, and then it's not a good thing. And that is kind of a problem that we have with that.
Well, I can tell you from my own experience, people I see, that there's plenty of people here who really don't like law enforcement that much. So I think it's always a mistake to stereotype people or communities.
Fair enough, Judge.
Then Anne did go on to say that she sent Mr. Edelman, the guy they hired to do the surveys, a copy of the non-dissemination order, but he didn't receive it. And she did take the blame for not knowing that and following up on that.
Our office did send Dr. Edelman a copy of the non-dissemination order. I didn't know he didn't receive it, but he didn't receive it. He definitely knows about it now. I would have caught that, but we didn't send him anything. Our process is to make sure that we have the signed order back from anybody that we're going to communicate with about the case. This solely had to do with him looking at what are the media stories, what are the big topics, so I can determine how saturated the community is and bias it. So that's why I didn't catch it. I'll take responsibility for that. But just to maybe allay some of Mr. Thompson's disappointment, it was sent. I don't know what happened, but he didn't receive it. He's sure.
And basically we ended with looking into doing those monthly meetings and then also having a hearing on April 10th at 4:00 p.m. to hear everything about whether these surveys can be redone in Latah County or whether they can merge the information with what they're doing in the other counties. And so Judge is not going to make his decision on whether the surveys can go forward until that hearing. So it was basically one big hearing to really get nowhere yet. But it was interesting to see the tensions between Judge and Ann Taylor, because I think she's been getting away with walking the line very often, and he finally put her in her place today, in my opinion.
So I don't know how you feel about 4:00 on April 10th. Could we just do that by Zoom, or do you want to be here?
Your Honor, Zoom would be fine with me. Mr. Koberger would likely not be present. If he's present by Zoom, I will be here with him. So
Okay, well, we can do it in person.
let's go ahead and do it in person. I'll change my visiting day to Wednesday instead of Thursday.
Okay. Is that okay, Mr. Thompson?
Yes, sir. We can be here 10th, 4:00.
And, Ms. Masseth or Mr. Nye or Ms. Beatty can participate by Zoom. Thank you.
Yes, sir. Thank you.
Because I want to make the best decision I can, if that's possible.